very essence of civil liberties certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. One of the first duties of government is to afford that protection. The government of the United States has been emphatically termed a government of laws and not of men. Howdy everybody, and welcome. You are watching The Defenders of Rights. Today we are going to pick up right where we left off. This is episode 1, part 2 of Learning the Law. Last thing we talked about was the AAA Digest of Motor Laws in Indiana, with the website highlighted as I have and showed up on the screen. And this particular website states that there are 6 classes of driver's license, and the first one it mentions is an operator's license. Now, funny thing about an operator's license, like I said, most of us were issued an operator's license. I want you to go ahead and get out your wallet, take a gander, look at it. You'll see it says Indiana Operator's License up at the top. Now I went ahead and dissect what an operator's license is. Let's go ahead. 140 Indiana Administrative Code, Section 7-1.1-1. Operator's license means the driver's license issued under Indiana Code Section 9-24-3, which is operator's license. So let's go to it, shall we? Indiana Code Title 9 Motor Vehicles, Section 9-24-3-4.5, Licenses Permitted Operations. B. The holder of an operator's license is entitled to operate a motor vehicle on a highway. An operator's license does not entitle the holder to operate the following. 1. A commercial motor vehicle. 2. A motorcycle other than an autocycle. 3. A Class A motor-driven cycle. And 4. Vehicle that is operated for hire. Then it goes to C and D, and we won't go into those. We're going to jump straight to E. A for-hire endorsement. So a for-hire endorsement under Indiana Code Section 9-24-8.5 entitles the holder to operate the following. 1. A motor vehicle that is A. registered as having a gross weight of at least 16,000 pounds, and B. used to transport property for hire. Number 2. A motor vehicle that is used to transport passengers for hire. Okay, that's what a for-hire endorsement does, added to your operator's license. It allows you to operate just what it said. F. The following are not considered transporting for hire. So these going to be mentioned are not considered transporting for hire. Let's go down to 3. Operating a motor vehicle that is A. registered as having a gross weight of less than 16,000 pounds, and B. used to transport property for hire. So, to me, that really contradicts itself. I couldn't understand this. I couldn't fathom it, actually. I couldn't find out the intent of the legislature and why they put it and worded it this way. I had to do some further research on this, because I wanted to understand what an operator's license allows you to do. So, if you recall, what we just read, Indiana Code Section 9-24-3-4.5, it mentions what an operator's license entitles the operator to do, which is operate a motor vehicle on a highway. And then it lists 4 things the operator is not entitled to do. Okay? And those 4 things are key. We're going to go over those. I made a chart, and you'll eventually see that. It helps you better understand what's going on here. And actually, I found the answers through, of course, case law. The whole for hire. What does for hire mean? Because obviously, in the definition of operator's license, F, the following are not considered transporting for hire, and then it mentions you operating a motor vehicle that is used to transport property for hire. I needed to understand it better. But first, let's jump to Indiana Code Title 9, Motor Vehicles, Section 9-24-8.5-6, Operating Privileges Granted with For-Hire Endorsement. So an operator's license with a for-hire endorsement entitles the holder to operate the following. 1. A motor vehicle that is A. registered as having a gross weight of at least 16,000 pounds, but not more than 26,000 pounds, and B. operated for the purpose of transporting property for hire. 2. A motor vehicle that is A. designed to transport fewer than 16 passengers, including the driver, and B. operated for the purpose of transporting passengers for hire. And B. The holder of an operator's license with a for-hire endorsement is not entitled to operate a commercial motor vehicle. So that's what an operator's license with a for-hire endorsement added onto it allows you to do. Obviously, B, it said an operator's license with a for-hire endorsement doesn't allow you to operate a commercial motor vehicle. Okay, so let's look at what a commercial motor vehicle is. Indiana Code, Title 9, Motor Vehicles, Section 9-13-2-31. Commercial motor vehicle has the meaning set forth in 49 Code of Federal Regulations 383.5. So we got to go to that. And of course, we've already read that. Let's go over it again. Commercial motor vehicle means a motor vehicle or combination of motor vehicles used in commerce to transport passengers or property. If the motor vehicles is a 1. Combination vehicle, Group A, having a gross combination weight rating or gross combination weight of 26,001 pounds or more, whichever is greater, inclusive of a towed units with a gross vehicle weight rating of or gross vehicle weight of more than 10,000 pounds, whichever is greater. And then it goes to 2, 3, and we need to go over those. That was the main section I wanted you guys to understand what a commercial motor vehicle is. So what we have next is the chart. This chart helps you understand better on what's going on, like I said. On the left column, you have the operator's license as defined in Indiana Code Section 9-24-3-4.5. In the middle column, you have endorsements, the for-hire endorsements, which is defined in Indiana Code Section 9-24-8.5-6. And then on the right column, you have a commercial driver's license, which is defined in Indiana Code Section 9-13-2-31. We just went over these. So this is basically what sums it up right here. The left column is the operator's license, the for-hire endorsements is in the middle column, and the commercial motor vehicles. Commercial motor vehicle is on the right column. You can go ahead and pause it on the screen. I want you to be able to take a gander at this. So let's go further. Here are a few court cases that will further assist in a better understanding of what the chart you just saw represents. Next we have Kelly versus Finney. This is the Supreme Court of the Indiana Republic in 1935. A very important case. In quote, the difference between the use of the highways in the transportation of property for hire and the use of the highways in the transportation of property not for hire is, we think, fundamental and inherent. This difference may not be reflected in the amount of miles traveled on the highways, but it is reflected in the nature of the business for which the highways are used. The one who uses the highways for the transportation of freight for hire makes the highways his place of business and an essential part of it, while the one who uses the highway in the transportation of his own property uses it as an incident to some other business. It is a well-established rule of law that the highways of the state belong to the state, and their primary use is for private purposes, and their use for transportation for gain is special and extraordinary, which the legislature may prohibit or condition as it sees fit. So in Kelly versus Finney, the Supreme Court of the Indiana Republic is only upholding precedents. And what is precedents? By definition, it is the established principles of law set forth by the highest court in the United States of America. And what is that? The United States Supreme Court. And from there, it trickles down. Next in line would be the Supreme Courts of the States of the Union. In this matter, and in this case, it is the Supreme Court of the Indiana Republic. And they are only upholding precedents. Next is Frohart versus Bassett. This is the Court of Appeals of the Indiana Republic in 2003. And this was what cracked the case. This court case allowed me to understand what for hire meant. End quote. Under Indiana law, an unexcused or unjustified violation of a duty dictated by statute is negligence per se. Specifically, the Froharts contend that Indiana law required Bassett to have a chauffeur's license to rent and operate the Penske truck, and that Penske and Kelly Shell allowing Bassett to rent the truck with only an operator's license constitutes negligence per se. So Bassett only had an operator's license to operate that Penske truck. Let's go further. End quote. Chauffeur is statutorily defined in pertinent part as a person operating a motor vehicle registered as having a gross weight of 16,000 pounds or more for the purpose of transporting property for hire. We've heard that before. Continuing on. For hire as used in the statutory definition of chauffeur, refers only to people who make the transportation of property their regular or primary business. So that's what for hire means. It means transportation of property, their regular or primary business. There it says it all. Now we can solve the riddle for the operator's license. Let's go further. Therefore, Appellee's defendants argue that because Bassett did not make the highway his place of business or even an essential part of it, he is not a person transporting property for hire. At the end of this court case, it says, in quote, Appellee's defendants argue that Smith and Redball actually demonstrate that for hire, as used in the statutory definition of chauffeur, refers only to people who make the transportation of property their regular or primary business. And we agree! As used in the context of Smith and Redball, as well as Kelly, we find that the meaning of the words for hire goes beyond a person transporting goods on occasion for compensation. Accordingly, we find that the designated evidence supports the conclusion that Bassett was not required to possess an Indiana chauffeur's license at the time he rented the Penske truck. Holy cow! So the Court of Appeals of the Indiana Republic in 2003 is declaring that Bassett did not need a chauffeur's license. He was okay with an operator's license transporting property on occasion for compensation. So that's what an operator's license does, ladies and gentlemen. It allows you to transport property on occasion for compensation. And I was never told that. I know you were never told that. Nobody was ever told that. Why? We can only begin to safely assume the worst. So let me sum it all up for you. The operator's license statute, Indiana Code Section 9-24-3-4.5, is very ambiguous and can easily be interpreted in many different ways that prevents anyone from acting or not acting on it. A majority of the private citizens have been unlawfully issued an operator's license. An operator's license is essentially a class of a driver's license in that the holder of an operator's license is entitled to operate a motor vehicle on a highway. The statute lists 4 classifications that the operator is not entitled to operate. Then, the statute gives the reasons why the holder of an operator's license can't operate those 4 classes, because the 4 classes require permits, motorcycle endorsements, for-hire endorsements, or a commercial driver's license. The individual would need more than just an operator's license to operate those 4 classes. 2 of those 4 classes are for-hire endorsements. The definition of for hire as used in the statutes and defined in the Court of Appeals of the Indiana Republic in Frohart v. Bassett refers only to individuals who make the transportation of property their regular or primary business. A for-hire endorsement entitles the holder to operate 1. A motor vehicle that is registered as having a gross weight of at least 16,000 pounds but not more than 26,000 pounds and used to transport property for hire, which is a chauffeur's license, and 2, a motor vehicle that is designed to transport fewer than 16 passengers, including the driver, and operated for the purpose of transporting passengers for hire, which is a public passenger chauffeur's license. But, of course, as the website told us from the Indiana Republic, that there's no longer public passenger chauffeur's license or a chauffeur's license, there's just for hire endorsements now. Then the statute clarifies what is not considered transporting for hire, meaning this privilege does not require a for-hire endorsement and does not go beyond a person transporting goods on occasion for compensation, which is to operate a motor vehicle that is registered as having a gross weight of less than 16,000 pounds and used to transport property for hire. In conclusion, the operator's license does entitle the holder to operate a motor vehicle that is registered as having a gross weight of less than 16,000 pounds and used to transport property for hire, meaning the transportation of goods or property on occasion for compensation. The foregoing court citations clearly show that the operator's license permits engagement in commercial activity and that a license is not required when a private conveyance or private automobile is used by the owner or his or her family for other than commercial purposes. Bam! Riddle has been solved. That's what an operator's license is for. So all you who have your driver's license out and up on top it says an operator's license, that's what you're allowed to do. You're allowed to operate a motor vehicle that's less than 16,000 pounds and used to transport property on occasion for compensation. That's what it's used for. Were you ever told that? Honestly, were you ever told that? Was any material fact of that nature ever disclosed to you? because it wasn't to me. It damn sure wasn't to me. Let's go further in it. Let's define compensation. Indiana Code, Title 33, Courts and Court Officers, Section 33-23-11-3. Compensation means any money, thing of value, or economic benefit conferred on or received by any person in return for services rendered, or for services to be rendered, whether by that person or another. So, now we know what an operator's license allows us to do. And of course, all the other classes of driver's licenses allows you to do something similar, and that is to operate a motor vehicle, which is a commercial conveyance used to transport persons or property for hire. So those who are not engaged or employed in highway transportation, those who do not drive or operate in commerce or are not engaged in any commercial activity upon the streets and highways, do not satisfy the requirements for obtaining a driver's license. How do we know this? Well, let's see what the Indiana Code says. Indiana Code Title 9, Motor Vehicle, Section 9-24-2-3. A. The Bureau may not issue a driver's license or learner's permit or grant driving privileges to the following individuals. 10. An individual who does not otherwise satisfy the requirements of this article. And who are those, ladies and gentlemen? Those are you and me, the constitutional private citizens of the Indiana Republic, or American citizens or state nationals, who use their private automobiles / private conveyances for private purposes. Let's go further. Indiana Code Title 9, Motor Vehicles, Section 9-18.1-2-2. Vehicles not required to be registered. The following vehicles are not required to be registered under this article. And number 7, listen to what it says. A vehicle that is not designed for or employed in general highway transportation of persons or property and is occasionally operated or moved over the highway. Yes, you heard it from here, the defenders of rights. Bam! The following vehicles are not required to be registered under this article. And that is a vehicle that is not designed for or employed in general highway transportation of persons or property. Everybody, those of you who are just using your private conveyance to go back and forth to work or to the hospital, to the doctor's office, to go to Walmart to purchase anything, to go to McDonald's and have dinner, have breakfast, whatever. Your private conveyance / private automobile is not designed for or employed in general highway transportation of persons or property. Okay? And it is not required to be registered. It says it right there. The next statute, Indiana Code Section 9-18.1-3-1, which is what we're about to go over here in just a minute, clearly confirms that the BMV employees are under obligation and are statutorily required to obtain information from the private citizens that will determine if they need to acquire a certain class of driver's license. This information that, by law, is supposed to be obtained during the application process of a driver's license is key, because that information will help the BMV employee determine if the private citizen needs a driver's license and needs to register their private conveyance / private automobile, or does not need a driver's license and register their private conveyance. So here we go. Indiana Code Title 9, Motor Vehicles, Section 9-18.1-3-11. A person that desires to register a vehicle under this article must provide the following information. 3. A brief description of the vehicle to be registered. 4. Any other information required by the Bureau, including B. A statement of the vehicle's intended use. How important this is, I can't express to you enough. B, a statement of the vehicle's intended use. That right there settles all disputes when you go in and register for your vehicle. That right there, a statement of its intended use, will declare if you do need a driver's license or not. And further in that statute is D, the declared gross weight of the vehicle is also required by the Bureau, which also plays an important part as well. The weight of the vehicle determines its classification. Pursuant to Frohart v. Bassett, the Court of Appeals of the Indiana Republic in 2003, under Indiana law, an unexcused or unjustified violation of a duty dictated by statute is negligence per se. The BMV has failed and failed again and neglected again to comply with statutory requirements when it comes to obtaining the information required from the private citizens who wish to register their private conveyances / private automobiles. If this information was gathered and processed properly, many applications would be denied because most of the private citizens do not use the public roads, streets, and highways for compensation or for hire, which is for commercial purposes. A majority of vehicles owned by the private citizens are not designed for or employed in general highway transportation and are not required to be registered pursuant to Indiana Code Section 9-18.1-2-2. A statement of the vehicle's intended use and or obtaining the weight of a vehicle would clarify this, but the BMV neglects to obtain and document this critical and important information. It is a well-established rule of law that the highways of the states of the Union belong to the states, and their primary use is for private purposes, and their use for transportation for gain is special and extraordinary, which the legislatures may prohibit or condition as it sees fit. The legislatures of the states of the Union may establish special limitations and regulations for their extraordinary use of the streets and highways, based upon the weights of vehicles. The resolution is, the gross vehicle weight or the gross vehicle weight rating of vehicles aid in the determination of their classification. Yes, they do. Weight plays a big part in determining what a vehicle is. It plays a big part in determining if you do need a driver's license and what class of driver's license. Let's go further. Let's define what gross weight is, declared gross rate or gross vehicle weight rating. Let's define all of this. Indiana Code, Title 6, Taxation, Section 6-6-4.1-1. Declared gross weight means the weight at which a motor vehicle is registered with 1, the Bureau of Motor Vehicles, or 2, a state other than Indiana. So the definition of declared gross weight already is tied with a motor vehicle. It says it right there in the definition. Indiana Code Title 9, Motor Vehicle, Section 9-13-2-71. Gross vehicle weight or gross weight means the weight of a vehicle without load, plus the weight of any load on the vehicle. So, the gross vehicle weight or gross weight deals with a vehicle. Not specifically a motor vehicle, but a vehicle. And if you don't specify what that vehicle is, it's automatically assumed to be a motor vehicle, if you remember right in the previous episode. Let's go further. Indiana Code Title 9, Motor Vehicle, Section 9-13-2-71.4. Gross vehicle weight rating means the value specified by the manufacturer as the loaded weight of a motor vehicle. So, as you can tell, that already is tied with a commercial purpose. Since motor vehicle is the conveyance used for commercial purposes, the gross vehicle weight rating is automatically for commercial purposes. Now we have a court case here in the Indiana Republic that declares what I've just said about the weight of vehicles. This is Richmond Baking Company versus Department of Treasury, the Supreme Court of the Indiana Republic in 1939. In quote, highways may be used for the transportation of persons and property for hire, subject to special limitations and regulations, and that discrimination may be made between those using the highway for public purposes and those using them for hire in a classification for taxation. The highways are public property. It is within the power of the state to require users of these highways to contribute to their cost and maintenance, and to require those who make special use thereof to contribute to their upkeep. The distinction between commercial motor vehicles and pleasure cars has been recognized from the beginning of their use. Such regulation, tax, or fee is not a burden upon interstate commerce, which applies alike to commercial vehicles, whether engaged in intrastate or interstate commerce. The weight, size, and construction of motor vehicles, whether engaged in intra or interstate commerce, affect the highways in precisely the same manner. The state may establish regulations and impose license fees as compensation for the use of the highway based upon load per axle or carrying capacity. So, as you can see, as declared by the Supreme Court of the Indiana Republic, that the weight of the vehicle determines its classification, as I was saying. And it's important there. In that court case, it says the distinction between commercial motor vehicles and pleasure cars has been recognized from the beginning of their use. So it all comes down to the use of the vehicle. It all comes down to that. And remember, if you recall, the BMV is supposed to obtain that information in Section 9-18.1-3-1. Any other information required by the Bureau, including B, a statement of the vehicle's intended use. The use determines it all. Another way of proving that private conveyances / private automobiles may not be registered and licensed is the taxes involved with the property in question. Indiana Code Title 9 Motor Vehicle Section 9-18.1-3-4. The Bureau may not register a vehicle unless the registrant, 2, provides proof in a manner acceptable to the Bureau that the vehicle is exempt from excise taxes under Indiana Code Section 6-6. All excise taxes are based upon the exercise of privileges, not constitutionally protected and secured rights and or the use of private property, in this case, a private conveyance/private automobile. So let's define excise tax. Black's Law Dictionary, 6th edition, published year 1990, page 563, defines excise tax, which is a tax imposed on the performance of an act, the engaging in an occupation, or the enjoyment of a privilege. Bam! Summed up right there. In current usage, the term has been extended to include various license fees and practically every internal revenue tax except the income tax. Let's go further. Whereas defined pursuant to Flint versus Stone Tracy Company. This was the U.S. Supreme Court in 1911. The United States Supreme Court asserted this. Excises are taxes laid upon the manufacture, sale, or consumption of commodities within the country, upon licenses to pursue certain occupations, and upon corporate privileges. The tax under consideration, as we have construed the statute, may be described as an excise upon the particular privilege of doing business in a corporate capacity. Example, with the advantages which arise from corporate or quasi-corporate organization, or when applied to insurance companies for doing the business of such companies. The requirement to pay such taxes involves the exercise of privileges, and the element of absolute and unavoidable demand is lacking. It is therefore well settled by the decisions of this court that when the sovereign authority has exercised the right to tax a legitimate subject of taxation as an exercise of a franchise or privilege, it is no objection that the measure of taxation is found in the income produced in part from property which of itself considered is non-taxable. Well said by the U.S. Supreme Court. And that was key right there when it mentioned franchise or privilege. Remind you, franchise is a big thing we're going to be discussing in another episode. Franchise is a privilege. It is a license. It is all synonymous. Let's go further. Here I have it posted up on the screen is a website which is uslegal.com. It defines excise tax law as an excise tax is a type of ad valorem tax that is imposed at the time of a purchase or sale transaction. So excise tax is considered an ad valorem tax. Okay, so what does ad valorem tax mean? According to Black's Law Dictionary, 6th edition, page 51, ad valorem tax means a tax imposed on the value of property. The more common ad valorem tax is that imposed by states, counties, and cities on real estate. Ad valorem taxes can, however, be imposed upon personal property. Example, a motor vehicle tax may be imposed upon the value of an automobile and is therefore deductible as a tax. So there you have it. An ad valorem tax is a motor vehicle tax. So it's an excise tax. So an excise tax deals with privileges. Operating a motor vehicle is a privilege. Let's go further. Indiana Code, Title 6, Taxation, Section 6-6-5, Chapter 5, which is Motor Vehicle Excise Tax. This is Indiana Code, Section 6-6-5-1. We'll go to number 4. Vehicle means a vehicle subject to annual registration as a condition of its operation on the public highways pursuant to the vehicle registration laws of the state. As a condition of its operation. In other words, the intended use of the vehicle's operation subjects it to annual registration. The intended use is either for private purposes or for public use, meaning operating in commerce or highway transportation. Private property, being one's private conveyance/private automobile, is not subject to annual registration. Only public property is, being motor vehicles, are subject to annual registration. Let's go further. Indiana Code, Title 9, Motor Vehicles, Section 9-20-6-12. The Indiana Department of Transportation may not issue a permit under this chapter for the operation of a vehicle if any of the following conditions apply. 3. The owner or operator of the vehicle has not registered the vehicle with the Bureau if the vehicle is required to be registered. If the vehicle is required to be registered. That is key. If. So it doesn't have to be. If it meets certain requirements, then it does need to be registered. But if it does not, then it does not need to be registered. So all of this applies to license plates and registrations as well, because it correlates with the driver's license. When you go get a driver's license, you got to get license plates, you got to get the sticker, you got to get the registration, you got to get it all. It's all commodities of commerce. So when a private citizen registers a vehicle, it becomes a motor vehicle. It becomes public property. In other words, the private conveyance / private automobile is no longer private property or owned by one individual. It becomes government property. The title an individual receives from the DMV or the BMV for their motor vehicle is just a certificate, the certification that a title exists. It just certifies that there is a title held in the government's name and the private citizen has permission to use this government property via the certificate of title. This is evidenced in Indiana Code Section 34-40-4-1. Indiana Code Title 34 Civil Law and Procedure Section 34-40-4-1. Certified copy as prima facie evidence. In a civil proceeding, a certified copy of a certificate of title is prima facie evidence of the ownership of a motor vehicle. Wow, that speaks volumes to those who understand what prima facie means. The legal definition of prima facie is defined in Harrington v. Hartman. This is the Court of Appeals of the Indiana Republic in 1967, when the Court of Appeals of the Indiana Republic declared prima facie means at first sight, on the first appearance, on the face of it, so far as can be judged from the first disclosure. Presumably, a fact presumed to be true unless disproved by some evidence to the contrary. Therefore, a certificate of title gives the appearance of ownership but does not provide absolute ownership of one's private conveyance or private automobile or motor vehicle to be exact. This is because a motor vehicle is public property, which indicates qualified ownership, meaning there is more than one owner of the motor vehicle. There's the private citizen and then there's the government. Besides the certificate of title, one must also pay a registration fee and get license plates for their property. Don't pay it, and the government will deny the use of this property. Not registering a vehicle makes the owner of the vehicle have absolute ownership or equity ownership and allodial title to it. Allodial is something I want you to be familiar with. Allodial, according to Black's Law Dictionary, 6th edition, page 76, means free, not holden of any lord or superior, owned without obligation of vassalage or fealty, the opposite of feudal, which doesn't say much, so let's see other definitions. According to Black's Law Dictionary, 6th edition, same page, 76, allodial freehold means owned freely, not subject to restriction of alienation that existed in feudal law. Land held absolutely in one's own right, and not subject to tenure of any lord or superior. Land not subject to feudal duties or burdens. Full and complete title to a land. Sovereign title to property. There. Now that really clears things up. Sovereign title to property. When you have allodial title to any property, that means you have it all. You own it completely. Allodial title to a vehicle means absolute ownership, indicating there's no taxes or other obligations and the vehicle belongs exclusively to one owner. If a private citizen is not operating in commerce or transportation, then he or she needs to avoid the DMV/BMV at all costs. To maintain one's privacy and not be subjected to the government's control, the process is called deregistration. The best process for doing this is not actually going through the DMV/BMV, but going through the Secretary of State and informing that individual in writing the intentions to remove the private conveyance/private automobile from the jurisdiction of this state. Now, do not say the state of Indiana or Indiana in place of this state. You specifically say this state. Then respectfully demand the Secretary of State to do a lien and title search against the private conveyance/private automobile and give him the VIN number to ensure that there is no outstanding liens, loans, or any other claims against the property in question. And once the Secretary of State certifies that there is no such claim against the property and that it is currently in the name of whoever it supposedly belongs to, then that's all there is to it at that point. Deregistration is no longer a big deal. Just let the registration expire and be done with it. No need to re-register ever again. Now, there is proof that the state of Indiana or any other of the 50 states has no financial interest in the property. Neither does anybody else within the jurisdiction of the state have a vested financial interest in the property. But now the issue here becomes is there has to be proof of proper ownership via a bill of sale. Because the certificate of title is not evidence of ownership except for legal ownership. It is not representative of equity ownership. The reason for that is because the State Business and Commerce Code defines a certificate of title as a negotiable instrument, meaning it's transferable. That's exactly why when someone sells an automobile, the only thing he or she has to do is sign the back of that certificate of title, just like they're endorsing a check and handing it over to someone else to cash their deposit. This is doing exactly the same thing with the certificate of title, except what's being exchanged isn't money, it's the private conveyance / private automobile. It works exactly the same way, but possession of the money is the only semblance of ownership one has, and in this case the private conveyance / private automobile. But equity ownership is different than legal ownership. Legal ownership only entitles someone to possession and use, but not disposition. In other words, under legal ownership, one can have the property in their possession, can use the property for whatever purpose he or she wants, but does not have the lawful authority to destroy or transfer the property. That is the way the courts determined its meaning and posted it in Black's Law Dictionary. In equity ownership, one can burn the property to the ground, can sell the property, can disassemble it and sell the parts if he or she desires, and there's nothing the government can do about it if she or she has equity ownership. That's the difference. That's why you can lease a car, but you can't sell it. You can't transfer it to someone else because that certificate of title is operating in essence just like a lease. For proof of absolute ownership, otherwise known as equity ownership, of a private conveyance / private automobile, one must obtain the certified bill of sale. And it never hurts to obtain the manufacturer's certificate of origin, which is the MCO, also known as the manufacturer's statement of origin, MSO. A manufacturer's statement of origin is simply the way that the manufacturer tracks the original part numbers for an assembled automobile. That's what it's for. It is so that if someone wants to certify the automobile as an all-original, for instance as a classic or a collectible, the MSO or MCO is the only way that one can verify that all the original part numbers match. Even if someone bought the automobile directly from a dealer, the necessity to prove absolute ownership is a certified bill of sale for the automobile. In common law, the highest proof of ownership is a bill of sale. The ultimate purchaser and the ultimate title rights derive from the bill of sale. Although in the Indiana Administrative Code, which is I-40 IAC section 6-1-0.5, it states a certificate of origin means the original ownership document provided to the initial purchaser, which is the ultimate purchaser, which begins the vehicle's chain of ownership. In other words, in Indiana, the document to provide actual ownership is the manufacturer's certificate of origin. This is reflected in Indiana Code section 9-13-2-111 and in 140 Indiana Administrative Code section 6-1-0.5c. So let's look into those. Indiana Code Title 9 Motor Vehicle section 9-13-2-111. New motor vehicle means a motor vehicle, 1, that has not been previously titled under Indiana Code 9-17 and carries a manufacturer's certificate of origin, or 2, that has never been transferred by a manufacturer, distributor, or dealer to an ultimate purchaser. So there you have it. Within that definition is the MCO and an ultimate purchaser, and that is a new motor vehicle. So a new motor vehicle means it has not been previously titled. So it has not been given ownership to the government, and it has not been transferred to any ultimate purchaser. Let's go further. 140 Indiana Administrative Code, section 6-1-0.5. C. Certificate of origin means the original ownership document for a vehicle issued by a manufacturer and provided to the initial purchaser of that vehicle, which begins the vehicle's chain of ownership. So, as I said, the MCO or the MSO is what you do need and want and desire, as well as the bill of sale to prove absolute or equity ownership of that private conveyance / private automobile. If you do have your vehicle already registered, which means it's a motor vehicle, that's what I mean by deregistration. You go through that process of what I just thoroughly went through. Get a hold of the Secretary of State, deregister it that way. So, without a contract, which is the bill of sale, or consideration, There is no DMV/BMV or government jurisdiction or control, as the property does not reside in the colorable fictitious territory, which is in this case state of Indiana, as evidenced in the U.S. Supreme Court case cited below. Whereas defined pursuant to Wheeling Steel Corporation versus Fox, the U.S. Supreme Court in 1936, the U.S. Supreme Court states, in order to have a situs for taxation, a basis for imposing the tax, tangible property, physical property, must reside within the territorial jurisdiction of the taxing authority. Remember that. And what a situs is for taxation deals completely with domicile. Situs, however you want to pronunciate it, it is synonymous with domicile. And domicile plays the biggest role in determining what laws apply to you. And it also determines if the constitutions are applied. The Indiana Code implicates most of statutory language and definitions from the United States Code and the Code of Federal Regulations, all deriving from Congress, the legislative branch in the United States government. The next few pages get into what is called the Supremacy Clause. A majority of the statutes and regulations pertaining to commerce enacted by Congress and codified in the United States Code and Code of Federal Regulations have been adopted into the Indiana Code. And it doesn't just stop there. All of the 50 states of the Union adopt and enact statutes that all derive from the United States Code and Code of Federal Regulations when it pertains to commerce. Now, the cases of Indiana Bureau of Motor Vehicles versus Orange Supra and State versus JS Supra demonstrates that the state of Indiana enacts and adopts the United States Code and the Code of Federal Regulations into the Indiana Code. We won't go into detail on those, I'll just say them again. That is the Indiana Bureau of Motor Vehicles versus Orange, which is the Court of Appeals of the Indiana Republic in 2008, as well as INRI JS, which is the Court of Appeals of the Indiana Republic in 2015. The Supremacy Clause of the Constitution for the United States of America establishes that a State of the Union laws are subordinate to federal laws and regulations. The Supremacy Clause contains what's known as the doctrine of preemption, which says that the federal government wins in the case of conflicting legislation. When there is a conflict between a State of the Union law and federal law, it is the federal law that prevails. The rationale for this rule is found in the necessity for uniform construction and application of such contracts and instruments throughout the United States. Therefore, when presenting legal words and definitions to a court, federal statute laws and definitions are controlling. All state vehicle code definitions yield to federal definitions. And the next few pages consist of court cases declaring this. One is United States versus Bevins, which is the U.S. Supreme Court in 1818. The next court case is United States versus Lopez, which is also the U.S. Supreme Court in 1995. Another one from the U.S. Supreme Court, which is Wabash, Street L and PR Company versus Illinois, the U.S. Supreme Court in 1886. And last but not least, Milk Board versus Eisenberg Company, the U.S. Supreme Court in 1939. Then the next few pages consist of definitions deriving from the United States Code as well as the Code of Federal Regulations. And we have gone over the majority of these definitions. One I do want to point out is the non-CMV definition, which is non-commercial motor vehicle. So for any of those who are speculating against all of this, pursuant to Title 49 Transportation Code of Federal Regulations, Section 383.5, the definition of non-CMV means a motor vehicle or a combination of motor vehicles not defined by the term commercial motor vehicles in this section. So anything that is not termed a commercial motor vehicle is a non-CMV. Now, the Indiana Republic has implemented and complied with the International Registration Plan Agreement as evidenced in Indiana Code Section 9-18.1-2-9. What is the International Registration Plan Agreement? Well, if you go right up above in Title 49 Transportation United States Code Section 14504A, Unified Carrier Registration System Plan and Agreement, there's a definition that I want you all to listen to. Now, I did a bunch of research on this, and this was the only definition I came across when it comes to the term vehicle registration. The term vehicle registration means the registration of any commercial motor vehicle under the International Registration Plan as defined in Section 31701, or any other registration law or regulation of a jurisdiction. Again, the term vehicle registration means any registration of any commercial motor vehicle. That, ladies and gentlemen, is simply saying when an officer pulls you over and asks for your license and vehicle registration, that's what he's initially asking for, is the registration that identifies any commercial motor vehicle. So when you go to register your vehicle and get that registration, you're ultimately registering your vehicle, your private conveyance / private automobile, into a motor vehicle, into a commercial motor vehicle. Let's go further. Indiana Code Title 9, Motor Vehicles, Section 9-18.1-2-9. A person may operate a vehicle that is an apportionable vehicle under the terms of the International Registration Plan upon a highway if the vehicle is registered under the International Registration Plan with a valid and unexpired CAD card. The United States Code 49, United States Code Section 14504A defines vehicle registration, which means the registration of any commercial motor vehicle under any registration law or regulation of a jurisdiction. So, when a private citizen registers their vehicles and obtains a registration, that registration identifies their vehicle or vehicles as a commercial motor vehicle. So, all of the Transportation Code, Motor Vehicle Code, or the subject matter involving traveling and using the streets and highways for commercial purposes was in fact originally enacted and remains today as remedial regulatory laws. The purpose of remedial law is to provide an injured party with the means to prove and obtain proper remedy for personal injury and or property damages, not to subjectively and punitively dominate the daily activities of any who might fall within the purview of the subject matter contained therein when there is no demonstrable breach of the legal duty resulting in personal injury or property damage. So the Transportation Code is remedial laws. And so let's define that. In Black's Law Dictionary, 6th edition, pages 1293 to 1294, remedial laws or statutes is defined as legislation providing means or method whereby cause of action may be effectuated, wrongs redressed, and relief obtained is remedial. Statutes which afford a remedy or improve or facilitate remedies already existing for enforcement of rights and redress of injuries. The underlying test to be applied in determining whether a statute is penal or remedial is whether it primarily seeks to impose an arbitrary deterring punishment upon any who might commit a wrong against the public by a violation of the requirements of the statute, or whether the purpose is to measure and define the damages which may accrue to any individual or class of individuals as just and reasonable compensation for a possible loss having a causal connection with the breach of the legal obligation owing under the statute to such individual or class. However, there is no claim of an injured party in most cases, and the state has no standing to make a claim of injury for itself where it cannot offer proof of any tangible injury or damage of any kind, as standing is just as much a due process requirement for the states as it is for we the people. Especially in a matter where the state itself is the sole accuser, witness, prosecutor, and judge, sitting in judgment as to the validity of any allegations made against whoever allegedly violated the Motor Vehicle Code, and others similarly situated solely by those who are paid to act as its agents and officers. These actors of the state cannot be reasonably said to act fairly and impartially when they each receive either direct or indirect personal and professional financial gain and other incentives to make such allegations and conduct such prosecutions as routinely as possible. So, the Bureau of Motor Vehicles is not acting in good faith and is knowingly and intentionally disregarding the constitutional and statutory duties required to reveal material facts such as obtaining the gross vehicle weight and the intended use of a vehicle, which is very important when dealing with licensing or franchising and registration of a vehicle during the application process. Most importantly, the BMV is licensing the exercise of constitutional rights, which is illegal, unlawful, and unconstitutional. And let's go ahead and define good faith for all you folks. In the Indiana Code, Title 34, Civil Law and Procedure, Section 34-6-2-64, in good faith refers to an act taken, 1, without malice, 2, after a reasonable effort to obtain the facts of the matter, and 3, in the reasonable belief that the action taken is warranted by the facts known. In essence, the courts, state and local law enforcement, the BMV and its employees, and other government agencies are racketeering, extorting the constitutional private citizens of the Indiana Republic / American citizens or state nationals, violating the RICO laws, which is located in Title 18, Crimes and Criminal Procedure, United States Code, Section 1951, and attempting to convert private property and private rights into public property, which constitutes conversion in violation of Title 18, Crimes and Criminal Procedure, United States Code, Section 654. Next, we have the definition of racketeering, extortion, and the RICO laws, all provided by Black's Law Dictionary, 6th edition. And you can read the definitions yourself up on the screen. And that ends this chapter into what the Defenders of Rights call learning the law. Obviously, there's plenty more chapters to go through, plenty more episodes to come. To sum it all up, what the first episode reveals. And I've just shown you all the facts and proof of law that claim is very true. And there's more to come to prove that. So anybody who is suffering at the hands of a corrupt government official, such as judges or police officers, and putting them through the courts, all because of driving while intoxicated, or driving without a license, or driving without insurance, you're more than welcome to utilize these videos. Definitely introduce them into evidence. Put them into discovery, because these are facts and conclusions of law that prove that you're innocent. We were all put under threat, duress, and coercion to obtain a driver's license when in fact most of us do not require it, do not need a driver's license because we don't operate in commerce. Because we use the streets and highways for what they were intended to be used for private purposes. Don't let no one else tell you any different. And I'd like to thank all the subscribers out there. Please, please spread the word, get our message across. Let others know about our channel. Hit the like button, subscribe, whoever is viewing this. We love to see everybody join in on the fight and understand and learn the law. And we like to thank the Lord for all of His blessings, for giving us the strength, the courage, the wisdom to do what's right and to fight for what's right. Because that's what we do. And we will continue to do so until the day we die. And that ends this episode of Learning the Law. Ladies and gentlemen, the Defenders of Rights, out.